Hey, this is Keith. Welcome to KeithSpeaks. Today, let's talk about something that should have every American paying attention, regardless of your politics, regardless of who you voted for. The Presidential Records Act. You probably haven't heard much about it, and that's by design. Here's what it is. In 1978, Congress, the legislative branch of this government, the branch closest to the people, passed a law. That law says that when a president leaves office, every record, every document, every communication created during that presidency belongs to the United States of America. Not to the president, not to his family, not to his lawyers, to you, the American people. Congress wrote this law for a specific reason. 4 years earlier, Richard Nixon resigned from the presidency in disgrace after Watergate. And the first thing Nixon wanted to do was control, or destroy, his own records. Congress said no, never again. These records belong to the public. That law has been on the books for nearly 50 years. Every president since, Democrat and Republican, has complied with it until now. On April 1st, 2026, and I wish I was making that date up, the Department of Justice dropped a 52-page memo declaring the Presidential Records Act unconstitutional. The opinion said the president need not further comply with the law. It claimed Congress had no valid legislative purpose in ever writing it. Let me be clear about what that means legally. An OLC memo is not a court ruling. It is not a Supreme Court decision. It is an internal opinion that the executive branch writes it to itself. It carries zero authority to override an act of Congress. The Presidential Records Act was never repealed. It is still the law of the land. A memo does not change that. But here's what a memo does do. It gives cover to people inside the government to act as if the law doesn't exist. And that's exactly what's happening. The National Archives Director was already fired. The replacement reports to the administration. When historians and watchdog groups went to court and asked the National Archives to simply agree, in writing, not to destroy presidential records while the legal challenge plays out, the archives refused to give that assurance. The DOJ said they were not yet in a position to make representations about whether records would be preserved. Let me say that again, man. The people responsible for preserving American history cannot promise they won't destroy it. Now, here's the question you need to ask. Why now? Why April 2026? Because the Presidential Records Act has a 5-year provision. Records from a president's term become eligible for public access 5 years after they leave office. Trump's first term ended in January 2021. 5 years later is January 2026. Those records, from one of the most contested, investigated, and consequential presidencies in modern history, are supposed to be hitting public access right now, today, this year. Watchdog groups had already filed sweeping FOIA requests for those first-term records, requests seeking documents on conflicts of interest, potential corruption, and abuses of power. And then the memo drops. Watch the pattern. This isn't about one president. If this OLC memo stands, if no court strikes it down, every future president can make the same claim. Every future administration can declare itself exempt from accountability. 700 million White House emails, decades of historical record, gone, controlled, hidden, or destroyed. The law exists. Congress wrote it. Congress has not repealed it. And no internal memo from any Department of Justice has the constitutional authority to override an act of Congress. That is not opinion. That's civics. The receipts belong to the American people. And right now, someone's trying to make sure you never read them. Watch the pattern. Connect the dots. And ask better questions. The receipts don't lie. I'm Keith. And this is KeithSpeaks.